Dr. Mrs. C. Tara Satyavadi will have her initial remarks, and this today's program is by awareness speech by Mr. Parvesh. Mr. Parvesh,
Kudroli.
can we see you?
Yeah, he's there online.
Yes, yes. Okay. So we'll have a program with Mr. Parvez Kudronil. He is the principal associate of Kurana and Kurana IPA attorneys. This is one of the ICR empanel IP attorneys. So he will be talking about all the IPRs, especially which is related to us, the patents, the copyrights, the trademarks, PPVFR and other things. So over to Dr. C. Tara Satyavadi, Madam, Director ICR-IMR and the Chairman of Zonal Technology Management Center, ICR-IMR, for initial remarks.
Thank you, Dr. Stanley. A very good morning to all of you. Mr. Parvez Kudroli, my fellow scientist, and people from other ITMUs related to JTMU of IIMR, and all other members who are participating in online and offline mode. So, a very good morning to you all. As clearly mentioned by Dr. Stanley, this is an initiative we have started to increase the awareness about patents, copyrights, and other related things in the wake of the new recent policy of ICAR in evaluating the scientists. That is, one scientist, one product, or one scientist, one technology. Since the evaluation of all the scientists is happening on this basis, so all the scientists should know, first of all, what are the different technologies they can uh, go for getting the technology certificates, and what are the things, the varieties where, as breeders, people understand how different cultivars can be developed, whether it is a variety or a hybrid and like that. But for other disciplines where either cultivars are not there or varieties are not there, how do they get there? One scientist, one product, one scientist, one technology. So in this background, it is very essential that they should understand how different technologies developed by them can be used for technology certification, and how they can be validated, and how they can get those technologies developed by them protected. So to understand all these details, we should first educate ourselves. And rightly, because uh, Purana and IAPRD is empaneled by ICR, we thought it is better if we can educate all of our people, our scientists, and those related with other ITMUs in this regard. And in this direction, the first beginning is made by Mr. Parvez Kudroli, who is a software inventor, patentee, and entrepreneur, and has obtained patents for his inventions in India and USA. And he's a very well experienced and established person in this field. And we thought we will open our series of these exposure programs to all our scientists and faculty in IIMR and other institutes through these things. So thank you very much, Mr. Parvez Kudroli, for accepting our request and to give online talk in this direction. Over to you. Thank you very much.
Thank you very much, Dr. Satyavati ma'am and Stanley sir, for your kind introduction. Good morning, everybody, and welcome to the session on Introduction to IPR, that is Intellectual Property Rights. Okay. Let me share my screen, and while I do that, we'll just give you an overview of how we'll be doing this. We have about 1.5 hours time to do this session, and I hope to complete within that time. Towards the end, if we can have maybe 5-10 minutes, if we get time, you can ask any questions also. But however, even during the session, if you have any particular queries which you feel are relate to the topic being discussed and they are important for you, you can unmute yourself and ask those questions. Okay. I will start with an introduction to various types of IPR, the four main categories which most people deal with in their personal or professional life. Okay. And then we'll look at more of patents, and we will especially towards later part be looking at plant varieties, because that is an important area of concern, for ICAR as well as related institutes. So really happy to be here, and I'm just initiating the PPT. Please let me know if you can see it. Is it visible to you now?
Yes, sir. Yes, sir. It is visible.
Okay, right. So let's begin. It's a pleasure to be here and to have this opportunity to conduct this session, share whatever information I have about this. As you saw in the introduction that ma'am gave, I'm not from the agricultural domain. My domain, basic technical domain, is in software and IT. But I work with inventors working in various different domains, not just in software and IT. So I'd like to share my experience based on that. But I'll be very frank with you in terms of plant varieties, etc. My knowledge and understanding of that is limited. But whatever I can share, I will share with you. And if you need further details, we could, I could connect you with one of my colleagues who can help you with the plant varieties protection part of it, especially. Okay. So let's begin. Okay. So what you see on the screen are the four main intellectual property right types that we deal with. Okay. Now, what you would see here on the screen is, I have not mentioned plant varieties here, but we will be coming to that. That's a little special category. Technically, it would have been possible even in India to have laws such that plant varieties could have been patented. But as per Indian law, the way the Indian government has done that, is not allow patents on these kind of plant varieties. Patents are not allowed, but there is a special unique category of intellectual property right, called breeders' rights or plant variety, protection of that. That act has especially been created, and plant varieties are protected under that particular law in India. This is what the Indian government decided under the commitments that they had under the TRIPS agreement. India is a signatory to the TRIPS agreement, so this is how it has been implemented. Nonetheless, for agriculture related entities, organizations, institutes, etc., it's not just that only plant varieties are important. Other types of intellectual property rights can very often be very important. In fact, most of the time, I would, hazard a guess that you would be filing these types of rights, mainly patent rights, or sometimes it could be trademark rights, or for certain things it could be copyrights, or in some cases it could even be industrial design applications. Because as I understand, there are a whole host of different activities that you do. It's not just breeding, certain type of plants, but so many other things also that organizations and institutes like yours, agriculture related, would be working with. There are different aspects to it, and we'll look at that aspect also. Okay. So this is just to give you an overview of things over here. Now, look at the four main types of intellectual property that is created and the intellectual property right that you obtain on it. On the right side of the screen is the intellectual property that somebody might create. Now, what is an intellectual property? First, the word intellectual or intellect, that relates to some creation of the human mind. Some person or a team of people get some idea in their mind related to some sort of idea which will have some utility and some commercial value in the world out there. Therefore, when they come up with an idea which can have value, which can be implemented in the real world out there, it has some use, and then it can have also commercial significance or benefits, then they would look to, suppose we bring out this idea, and once we document this idea and give it to somebody, everybody will start copying this idea, because it's very easy to copy intellectual property. Okay. Unlike physical property, It's very easy to copy intellectual property ideas. Once they are documented and shown to one person, then it can go viral and literally thousands and lakhs of people can get copies for almost zero cost, right? It's not so easy to copy physical property. Like, for example, if I own, 200 acres of land, say in Bangalore or somewhere, right? Now, nobody can copy that 200 acres of land and distribute to 10 lakh people, right? It's not possible. Or if somebody owns a car, nobody can make a, copy of the car or do a 3D printing of the car, and it will not work like that. It's not easy to copy physical property, for people who want to steal and copy. It's not easy. But ideas, once it's documented, it's very easy to copy that idea, make distribute it, and the person who came up with that intellectual property idea doesn't get the benefit of creating that idea. Everybody is copying, and the copy is as good as the original when it comes to ideas, copying ideas and documentation, etc. This is the challenge that people who work with their intellect, who come up with new ideas, and these ideas are not theoretical and useless ideas. Such things generally, would not be considered as intellectual property or protectable through IP rights. But ideas which have some practical use, they can be implemented. Lakhs, thousands of people in the world out there can benefit by implementing, using, or practicing those ideas. Such ideas require laws created by the government in each country to protect those ideas and to take legal action against people who are copying those ideas and using it and misusing it or deriving benefits from those ideas without the permission of the author or the creator of the intellectual property, right? This is the whole concept of intellectual property rights. So intellectual property, what you see on the right side of the screen, is the idea that a person or a group of people might create in their minds. Then they'll document it and then they'll try to implement it. But before implementing it, they will want to consider protecting that idea by applying for and obtaining an intellectual property right. The important word to note here is right. You create an idea, you have an intellectual property, but that intellectual property is unprotected unless you go and apply to the corresponding government office, the patent office or trademark office or design office or copyrights office or whatever is the relevant office. You apply to them and say, give me a right on this intellectual property. If I don't have a right on this intellectual property, my intellectual property idea is free for use, misuse, copying, and utilization by other without my permission. I don't want that. Okay. We have spent time, effort, and money creating this intellectual property idea. It didn't come to us for free. So we want to have protection. We want to have the right to take legal action against infringers, copiers, and thieves who copy our intellectual property idea. So this is the whole concept of intellectual property idea, concept, know-how that you create, and then to protect that so that people can't copy it. And how do you protect it? By applying for and obtaining a right on that intellectual property from the relevant government office. Now, let's quickly go through the different types of intellectual property ideas that people might create, and what is the intellectual property right that you will or you should or they should apply for, which is the appropriate type of right to obtain. Suppose you have come up with the idea for a technologically improved invention, means you have come up with an idea for a new or an improved product or process. Okay, such a new or improved product or process, how will you protect? By applying for a patent for that new or improved or process idea. Okay, so the intellectual property is the invention, means a new product or improved product or process. That's the intellectual property idea that you got, and you have also documented it. You put it on paper, you made drawings, you've given a detailed technical explanation of how it works, what it involves. It's everything is there. Now, what the right you should apply for will be a patent right. Okay. Suppose you have come up with an idea for, now what people might ask, what could be a technical or technological innovation? What could be a product? For example, this mobile phone or a part of it. For example, the display in this phone. Okay. If I come up with a better display which has much higher resolution compared to existing displays, now that's an improved product idea. If I come up with a method or a process of manufacturing this mobile phone such that it takes half the time to manufacture this mobile phone. So manufacturing process for mobile phones are known, but I come up with an improved process whereby I can manufacture that phone in half the time. Is that not a technically advanced, improved process of manufacturing the mobile phone? Now, same concept will apply to various different products and processes in different industries, including mechanical, electrical engineering, aeronautical, agricultural domain. You know, there are new products coming up, there are machines, there are compositions, there are methodologies for doing things, making things, testing things, using things, etc. All these things, technical things, technologies, when somebody comes up with an improvement, technical improvement, then you can protect it through patent right. Now, the second type of intellectual property and right that you see is the intellectual property right is an aesthetic design applied to an industrial product. And the intellectual property right that you should apply for in case you have come up with an aesthetic design will be an industrial design registration. That is the application that you should file with the Indian Design Office to protect your aesthetic design. Okay. Now, what is an aesthetic design applied to an industrial product? Okay. First, let me say what's an industrial product. Again, you know, this bottle that I have is an industrial product. This pen that I have, industrial product. This mobile phone is an industrial product. A car, a chair, a table, a light, fan, glasses, bottles, computers, all these things are industrial products. Okay. And what you would notice about these products, for example, look at this bottle. Can you see it has a particular distinctive shape? Okay. Now, because of the shape of the bottle, the working functionality of the bottle is not affected, but it gives it a distinct look, an aesthetic. It's an aesthetic, good looking design. So here you want to protect that particular design or shape, which is not functionally useful, but it gives it a unique look. It makes the bottle look good. Okay. Otherwise, it could have been a very ugly looking boxy shaped bottle, but it's made in a nice curved shaped design. So that good looking design that you apply to industrial products, such as maybe even, for example, the mouse that I'm using. Can you see it has a nice curved shaped design? It could have been a rectangular or a box shape ugly design, but no, it has a good looking design. And I bought this mobile phone, this mouse because it has a nice, good curve shape, good look. So I want good working mouse. It should do its functionality. It should work well. I also want this to look good. The products I use to look good. Okay. The look good part of it, that design element which makes it look good is protected through the industrial design registration. And I'm sure all of you or most of you, most human beings have this desire that any product they buy and use should be not just working well, but they should also look good. Like, for example, cars or mobile phones or bikes, or even the fans that people have, they buy such good looking decorative kind of designs of the fan. The clothes that you wear. Okay. Children, when they go and buy a pencil box, they don't want a box shaped dabba type pencil box, unattractive looking. They want a good looking, nicely designed pencil box also. Although functionally it doesn't matter, but people, human beings, being emotional beings, are very interested and they give value and they are willing to pay more money for good looking design. So that's what an industrial design registration protects. Now, the third category of intellectual property that you see on the screen are branding related marks, which any company or organization or person uses to identify its products and services which that entity is selling or providing in the market. Okay. So branding related marks include logos, word marks, taglines, etc. Okay. For example, there is this company PepsiCo, which has a brand Pepsi, and it has a round, red and blue logo, and it used to have a tagline, "Ye dil mange more." Okay. All these marks are created, identification marks, to identify the source of origin of that drink, of that product, that it's coming from this company called PepsiCo. It has a certain brand value, it has a brand positioning, certain quality standards are implicitly assured through that branding. Okay. Such branding related marks you will protect through trademarks. And even in the agricultural domain, some people will be wondering, why are we talking about trademarks and copyrights? We are like in the agricultural domain. Why are we doing? Even for your agricultural products, these are important branding. identifying the source of origin, which is the entity from which these products are coming, who has grown this, who has tested the quality, who has certified this, who is verifying or vouching for the quality of this product. All these will be achieved through branding marks, trademarks, identification marks. And how do you protect such branding related marks? Through trademark registration of those names or word marks or logos or taglines or combinations of this. Okay. So branding related marks which identify the source of origin of goods and services are protected through trademark registration. Okay. Now the fourth category of intellectual property that can be created that you see on the screen are literary, artistic, cinematographic, musical works. And as a special case, even software programs can be registered as copyright. The program itself, the source code, the exe file, the user interface elements, your data structure, etc., can be registered through copyright. So such expressed works where the value of that work is in the expression, you will protect through a copyright registration application. Okay. Now, what do I mean by expressed work? For example, a literary work. Let's take the example of a book. Somebody writes a book. That's a expression. What is the expression of that book? For example, a book means something like this. Okay, this is a book. It has written matter inside. It has lines, sentences, paragraphs, phrases, words, tables, pictures, photographs, etc. These are expressions. If I read the book today and then I read this again after 50 years, what is written in the book, the expression will remain the same. The same words will be there, same photographs will be there, the same sentences will be there. So the expression is what gives me value in a book. The word, the sentences, the tables, the photographs is what is of value to me, and that expression is fixed and it stays steady after 10 years, 50 years, or 100 years. So that fixed expression which provides the value of that work is what is protected through a copyright, not the idea but an expression that is protected through a copyright. Okay. Just to give you an example, imagine there is a big production house which makes a movie. They take 1 year and they spend 100 crore rupees and 500 people work for 1 year to make a movie. Okay. And at the end of 1 year, what do they have in their possession? They have a recording of a movie, audio visual recording of a movie, and these days it will be on a computer readable medium, right? So that is the expression, the movie recording, which somebody can watch the movie, hear the dialogue, the songs, the background music and sound effects and all that. You can see the movie and you can hear the sound associated with the movie. That's an expression, and that has cost, just to get that one file has cost how much? 1 year of 500 people and 100 crore rupees, right? Now imagine if everybody was free to copy, all the thieves can freely copy. That would be a disaster for the production house or the producer who spent that 100 crores, right? So that's why you need copyright protection to protect that recording, that expression, such that anybody copies that without permission. In other words, they are stealing a copy and distributing and misusing that without permission. Legal action can be taken against them under the copyright law. Okay, so this is the meaning of expressed works like literary, artistic, cinematographic, musical works, and protection under copyright. Even technical know-how, which you might not have otherwise protected through some other thing, or some guidebook or some help documentation about the work or the products or processes that you people come up with, can be protected. That documentation can be protected through copyright. It could be some video that you have made, how to do this, how to make this, how to run this machine, or how to conduct this test, or how to do the planting and all that stuff. That can be protected. It could be a book, it could be a song, a sound recording. Somebody has done a podcast, there's a recording of that. It could be photographs of important work that you're doing. All these expressions are protected through copyright. Okay, so I hope all the main types of intellectual property rights are clear to you, and why especially I emphasize giving a brief introduction to these different types of intellectual property rights is sometimes some people, due to their lack of awareness and because nobody told them this or clarified this, somebody might come up with a technological invention and prepare a document for that. They'll document what is that invention. And you know what they'll do? They'll not go and file a patent to protect that invention idea, the new product or process idea. since they have a document in their hand with words and images and tables, etc., they go and file a copyright application on that particular documentation. In the process, what happens is that technical idea for that invention, improved product or process is unprotected. What gets protected is only the words, the documentation, the table and images which are there. And what is the nature of a copyright protection? If they have gone and applied for a copyright, the nature of copyright protection is nobody can make copies of the document. Means they can't make a Xerox copy of that document. Okay, they can't make a photocopy of that document, right? But anybody can read that document. It's copyrighted document, but everybody has a right to read a legal copy of that document, and they'll get the invention idea. Somebody has come up with a better way of constructing maybe a tractor or something. Okay, improved process for making or using a tractor, that is written in that documentation. Now the person has not gone and filed a patent on this is how you make the tractor, or that concept, the idea itself, nobody's patented. They took that document, this is how you make the tractor, and those words are protected. Now somebody will read that document, all that know-how, that expression is uploaded in their head, and then they go and practice the idea. When they are practicing the idea, what they are doing, they are taking action to manufacture the tractor in that way or use it in a certain way. They are taking action. And when they are doing this, they are not making a photocopy of the expression, that document, no? So therefore, if somebody has not filed a patent on this process idea, they've only got a copyright, the idea remains unprotected. Don't make this mistake ever. If you come up with a technologically innovative idea, go and file a patent for the idea. Don't prepare a documentation and get a copyright on that documentation. That document copyright protection is very weak for technological inventions. Okay, people can not make copies of the document, but they can read that document legally and then practice the idea, and nobody can stop them from practicing the idea because the idea itself has not been patented. One expression, one written documentation about the idea has been copyrighted. That's a big blunder. So don't make these kind of mistakes. Similarly, if you have come up with a good logo, don't go and file a copyright application for that. You should file a trademark application. If you've come up, written a nice book with a nice story, don't go and file a trademark or a patent for that. You should file a copyright application for that. This is something that you should understand. Depending on what kind of intellectual property idea you've created, go and file the appropriate intellectual property right application for that. Very important to understand. Because what happens is when people file the wrong application, they don't know they have filed the wrong application. For a technology, they filed a copyright, they don't know it's a wrong thing they have done. And they go and tell people about the invention. They talk to people about the invention and they say, you know what, I have got IP protection on this technology idea. They are under the misconception that they have got some protection. Because they have actually not filed a patent, they filed a copyright, they have no protection. So apart from the fact that they don't have protection, the bigger damage is caused to them. Their credibility will be lost because actually there is no protection. They think they have protection under copyright, but they have no protection. So under that misconception, they'll go and disclose, tell people about it. Everybody starts copying. And then maybe after 1 year, 2 years, 3 years, they'll say, oh, why are these people copying when I have got a copyright and IP protection on this idea? I had filed a copyright on this idea. That document I filed as a copyright. So let me go and stop them. And that's when they realize the big blunder that they have done. Using copyright, you can't stop anybody from copying and practicing your idea as long as they don't make a photocopy of your book, right? Where you've given all this documentation, right? This kind of blunder, none of us wants to make that. None of us wants to be in that kind of a bad situation. And people will laugh at that, technically very qualified expert person and came up with a great invention idea for a new product or process, and the person didn't even have the understanding to go and file a patent and protect the technology idea. They filed a copyright, and now you can't later on rectify that error. Once it's in public domain, then you can't go and file a patent on that. Permanently lost that technology or that product or process idea. Okay. Another last thing I want to say based on the IP right types on the screen over here is the first two categories of intellectual property rights And the second last two categories of intellectual property, that is, in case of patents and industrial design registration, if you want to protect a new technology or a new aesthetic design, you must keep that technology or design secret when you're creating and documenting it. Then go and file the patent or industrial design application. And only after you have filed the application, one day after the application you file, then only you can disclose or use that technology or that design in public. Till then, it has to be kept secret. If you want to protect that technology or that aesthetic design. If you don't want to protect, then obviously you'll not file a patent or industrial design application, right? You'll give it to people for free. But if you want to protect some idea for a technology or a design, aesthetic design, then you must keep it secret, work on it, develop it, document it, get it proper patent or design application prepared, filed, and only after that you should disclose or use in public. Till then only it should be disclosed on a need to know basis. The people working on it, or the department head who decides about should we protect this or not, the management, etc., who are decision makers, right? Other than that, it should be kept secret. The situation is opposite when it comes to trademark and copyrights. Okay. In case of trademarks, you can use a trademark for 5 years, 10 years, 15 years, and after 15 years, you can still go and apply for registration of your trademark. Okay. In fact, if you go and apply for after 10 or 15 years of use, your application will be quite strong. Okay. So trademark rights accrue when you are actually using that mark in trade, and you can apply either before you start using or after you start using. Similarly, when it comes to copyright, when you create a copyrightable work, that expression, that book, or that music recording, or any artistic work, the moment the work is in existence, you have automatic copyright. You don't, it's not a mandatory to go and apply for copyright registration and get a copyright registration certificate. It's not mandatory. Okay. And you can apply before you publish it, or 1 year after you publish it, or 10 years after you publish it, right? It's up to you, right? So the situation here in terms of when to apply, when to disclose use is very different when it comes to patents and designs, where you have to keep it secret. And it's very different when it comes to trademarks and copyrights, where it's not mandatory to register, as well as you can register it later on. But nonetheless, it is our recommendation that for important trademarks and important copyrightable works, you should go and apply for registration as soon as possible. Because in case somebody starts copying it, then it's very important to have your registration certificate, which in other words is your ownership proof certificate. Okay, that proves that you're owner of this trademark or this copyrightable work. If you don't have that certificate, you haven't applied, it's not mandatory. Then if you want to take action against some copier or infringer, first you'll have to fight a battle in court with the other guy. He is also making a claim, this is my trademark, my copyright. You are also making a, it is my trademark, my copyrighted work, and both will argue on who's the real. So 6 months, 1 year, 2 years get wasted in just trying to prove your ownership. Only after that you can take action. And if the order comes that actually the judge gives an order that this copyrightable work doesn't belong to you, you haven't given evidence, it belongs to that copier, then you're in trouble. You can't even enforce that copyright. Okay. So for important works, nonetheless, you should file a copyright or trademark application. Very important to understand this. Let's go to the next slide and look at an example of, suppose somebody has created some intellectual property idea or something intellectual property. What is the IP right that one should apply for? For example, I have created a new product design. The question that arises is, when you've created a new product design, should I file for a patent or an industrial design registration? Now look at the screen, the glass on the left side of the screen. Assume that it's old technology, it's known existing technology. There's nothing new and innovative. Assume the plain glass on the left side of the screen is a glass which is known last 400 years or 500 years or 600 years. It's public property. Everybody knows, everybody is using. So nothing new, innovative, nothing new. Therefore, nobody can register either a patent or a design or any other intellectual property right, because it's public property. No private party or individual can have a ownership, because nothing new and innovative in it. Okay. Now look at the glass in the center of the screen. Now here you can see that this glass looks different. It has a nice curved shape design with certain markings and engravings on top of this. Okay. Now can you see this glass is different from the glass on the left, and in particular this glass looks different from the glass on the left, right? And as we saw in the previous slide, what we discussed, when you apply a design to an industrial product, now a glass is an industrial product, by the way, okay? When you apply a new good looking aesthetic shape or a design to an industrial product, guess what we should do to protect that intellectual property, which is the new aesthetic design? We will file an industrial design application for this, right? I'm sure everybody is in agreement with me that when you are using this glass in the center of the screen, it will work the same way as the glass on the left side of the screen. For example, if you are drinking some water using this nice, good looking curved shaped glass in the center of the screen, the water will not be sweeter or salty just because you are using a curved shaped glass. Okay, the water will not feel hotter or cooler or cold just because the shape of the glass is different. In other words, the functionality, the working of the glass is unaffected because of the shape change in the glass. Okay, the shape is merely good looking. The shape doesn't provide any better working functionality. In other words, there is no improved technology here. There's just aesthetic design. So you'll go and file an industrial design application on this, right? If anybody has any question or doubt about this, please unmute yourself and ask me the question. Okay. So what I'm saying here is this is merely a good looking aesthetic, differently shaped glass design. Therefore, doesn't make sense to file a patent on this. What you should file is a design application, an industrial design application to protect the IP, which is a good looking aesthetic design. That's the intellectual property idea, how to give what kind of shape to give. Okay, so let's go further in this example. Now look at this glass on the right side of the screen. In fact, it's the same old glass which you saw on the left side of the screen, that plain, non-innovative, not new, old design glass. It's same glass, but this glass on the right side of the screen is different, right? As you can see, it looks different because this glass on the right side has a handle attached to it, right? So it looks different. That gives us a clue that it looks different. Possibility is there that we can file an industrial design application on the glass on the right because it looks different. It has a different shape. Okay. Second aspect that you need to think about is, do you think a patent can be filed for this glass on the right side of the screen? Can it be filed? Okay. And if so, why do you think it can be filed? Okay. Now imagine that somebody is drinking maybe some hot water or some hot tea or hot liquid using the glass on the right side of the screen. Do you see there is a improvement or there is a impact on the usability of this glass because of the handle attached? Suppose I'm drinking a hot liquid from a glass or a vessel or a container and I'm holding it directly. There's no handle, so I'm holding the glass itself directly. Now imagine if that liquid inside is very hot, the glass will become hot, my fingers will be burning, it will be very uncomfortable. I might even drop the glass if it's very hot, right? But if there's a handle attached to the glass, as we can see on the right side of the screen, we will hold that glass having a hot liquid using the handle. It will be very comfortable, convenient to hold. My fingers will not burn, and it will be a good experience holding and drinking that liquid, right? Now, can you see here that because of this new design, and the new design comprises of a handle attached to the glass. That's the new design concept. Can you see, because of this new design of the glass, the working, the functionality, the usability and convenience of this product has improved. In other words, there is a technology improvement or advancement. It's not just merely a good looking or a different looking design on the right side of the screen. It is actually a better functioning, a better working design of the glass. There is a technology improvement because functionally there is an improvement. There's a technical benefit here, right? Get this? So in this case, you can also consider filing a patent application on this because it's a functionally improved design. Okay. And we saw a little while back, we discussed, okay, you can very file a design application because this glass looks different from the two other glass which you see on the screen. It is different from the other glasses which are already in existence. This glass looks different, it works different. Okay. Now, let me ask you a question. Here, there is a possibility that you can file a patent application, you can file a industrial design application. and maybe you can file both, or maybe you can file zero. What do you think should be done in this scenario? Which application should be filed? Which one or which two, or should none be filed here? You can unmute yourself and answer this question if you'd like to do that. Okay, this is my question to you. Should we file a patent? Should we file an industrial design? Should we file both, or should we file nothing in this case? The glass on the right side of the screen with the handle. For this new intellectual property idea, this IP, which kind of IP right should we file for? Just think about it for a moment, and if you want, you can unmute yourself and ask or say anything regarding this. What do you think should be done?
Sir, I suppose it's a better functionality has improved. So we have to file a patent only.
Oh, so you are saying patent only. You are not saying, okay, that a patent can be filed. Okay, you're saying a patent only should be filed, right?
Yeah. Why I'm telling is, if patent is filed, then it is protected much stronger than industrial design, no?
Right. Perfect answer, right? See, technically we can even file an industrial design application, right? But just think about what would be the most appropriate type of IP right to apply for this, right? Now, when this person who designed this new glass with a handle came up with a design idea and they attached the handle, what was their thinking? What was their purpose? What was the outcome they were looking for? Did they attach the handle because they wanted a different looking glass or a different or better looking glass, or did they attach the handle? What do you think? I'm asking you. Did they attach the handle so that it is more comfortable, convenient, easy to use, and there's a functional improvement in the working of the glass? What do you think was the reason why they made a change or improvement in the design? Right? Yeah. The answer to that, I'm sure most of you will agree, the reason for making this design change is not that they wanted to make it look different or better or more beautiful looking, good looking. No, that I don't think was the primary purpose of attaching the handle. Primary purpose of attaching the handle, as sir just mentioned, was to make it functionally better, to make the glass work better, more convenient, easy to use. Usability, utility was the reason for attaching. So when we have functionally improved designs, functionally improved technologies, what do? The most appropriate type of IP that you could apply for would be a patent right. Okay, so that was exactly the perfect answer to this question. Okay, and see how you understand this. What is opening up for you? What do you understand about when you do come up with some idea of what is the IP right that you should apply for? Now here, to further this understanding, a few points let me share with you. Firstly, when you apply for a patent right and when you apply for an industrial design registration right, the process, the level of difficulty, the cost required are involved, the time required to get a patent registration or design registration, these are very different. Okay, patents are much more difficult to get. They are much more time consuming. You have to give detailed descriptions, drawings, views, explain the technology in detail for patent. Okay, and it costs a lot of money, much more money compared to a design application. In a design application, you just have to give images of the new design. Means, look, take this glass, take a left view, right view, front view, back view, top view, bottom view, perspective view, images, and say it's a glass. What I want to register the industrial design is a glass. This is all that you require to file a design application, industrial design registration application. It takes much less time, it's much less costlier, okay, and it gets granted much faster, okay. So patents are much more costlier. Uh, Costly, instead of using the word costlier, I'll use the word resources intensive. They require more resources. And by resources, what I mean is not just the monetary cost, there is also the time cost and there is a attention cost. Your time, money and energy and attention gets used more when you're applying for a patent. It's much more costlier and resources in a patent. Design is much cheaper, right? But nonetheless, in this case, you will still go and file a patent if you really want to protect the concept of, and let's look at, I'm talking about the concept of this invention. What is the concept of this idea? One thing you see here, glass with a handle. It looks different, okay? But as a conceptual idea, as an improved technology idea, how will you put that concept across? You will say a glass with a handle, okay? But maybe your friend or your colleague might say a glass made of glass material with one steel handle attached at the upper side of the glass. Both ways are correct, right? If you look at the glass on the right. Okay. But the first description or explanation or statement of the concept is better from a patent perspective, where somebody says it's a glass with a handle, or even better if somebody says it's a container with a handle. Somebody says that, that's a better way of presenting or verbalizing or expressing your invention concept, because you're not doing what the second person has done. The second person has said, okay, I have invented a glass made of glass material with a steel handle attached to one steel handle attached to upper part of the glass, right? Okay. So the second person, can you see, is not talking about the concept of a container with a handle, right? They are talking of one implementation of that concept, wherein in that implementation, an exact physical product that you're making, you're choosing to use glass material and you're choosing a steel material for the handle, and you're choosing to attach only one handle, and you're choosing to attach that handle at the upper part of the glass, right? The second person is not describing the invention concept, the broad idea. They are actually describing one way of practicing or making that concept idea into a real glass. Okay, because a real glass, when you make it, can't be made of theoretical material. It can't be unspecified. It will have to be glass or steel or copper or wood or ceramics or some such material, right? So the second person is not describing invention concept. They are describing how to physically implement the idea of the container with a handle. Can you see the difference? The concept itself and one implementation, one one prototype that you make. You don't want to patent the prototype or the implementation. You want to patent the invention concept itself, right? So in patent, you can do that. So suppose I were to, firstly, I would file a patent for this. Secondly, when I file a patent, many of you might know, might be aware of this. Patent needs to have a detailed description, drawings, etc. And below the description section, there's a section called the claim, where you actually not explain or describe, but you point out and list and highlight what are the innovative technical features of your invention. That is called the claim section. The claim sections are to be brief, and they should focus exclusively on what is the new improvement or innovation in that technology or the product or the process, right? So there, when I write a claim for this, I will write a claim which will simply state a vessel with a handle. That's it. My claim done. That's my invention concept. If I write in that claim a glass made up of steel with a wooden handle attached to it, where the glass color is brownish and the handle is yellowish, okay, and there is only one handle attached. If I put these kind of details in my claim, the scope of protection that I get on my concept gets very limited. Because if somebody else makes a glass where the glass is made of ceramic, it's a container, okay, and the handle they make of wood, and the glass color they make is pink, and the handle here these people make is red, then they avoid your patent, because you have written a claim. The second person has written the very narrow claim talking about the implementation details. They have written a claim talking not about only the invention concept broadly, but the implementation details. They have said, my glass is made up of steel of this color, and my handle is made up of maybe copper or something of that color. And then somebody is implementing with a different material. They make a glass of wood, and the handle they make of ceramics. So then it fits in with the claim, broad claim. Suppose you had written of a container with a handle, whatever color it might be, whatever material it might be. If you attach one handle or two handle, if you attach the top handle to the top or the bottom, if the handle is made of wood, ceramic, a statement, a claim which says a container with a handle covers any implementation of that invention idea. Okay. But if you write a detailed claim specifying the material used, how many handles are there, what is the color of the glass, the container, or this, it is unlikely that anybody else will infringe that. Okay. So patent protection is strong if you are able to capture in your claim the invention concept and keep out the implementation details. They understand the difference between inventing a new improved technology, expressing that invention concept in very few words, And then later on to implement, you can't theoretically implement, you'll have to decide when we make our prototype or our model, should we use glass, should we use ceramic, should we use wood, and what will the handle be made of? Will it be wood or will it be plastic or what? Then you have to decide. But when you're patenting the invention concept, don't bring such implementation details into your patent claim in your patent. Okay, in your description, you can mention this. The container that we spoke about can be glass, steel, copper, wood, ceramic, blah, 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 blah. You can also mention in your description of your patent application, the handle can be one, it could be two, it could be on the upper part of the glass, bottom part of the glass. It could be this color, it could be that color, it could be ceramics, it could be plastic. Description of your patent you can mention, but in your claims, if you want strong protection on the basic concept, the idea, you will write a container with a handle is my invention. Somebody puts a container with three handles, your patent still covers that. Somebody makes a green colored container, your patent covers that because you haven't specified these things, means you are covering everything. Anybody makes a container and a handle, your patent applies. They implement it in whichever they want. You can go and sue them for infringement, saying my container with handle concept you copied. Maybe whatever color or material doesn't matter to me, but my patent is on container with handle. Can you see patents are one of the strongest forms of intellectual property rights? And
Hello.
for technology, they're the best way of protecting the technology in a very broad way. And there also you have to be careful and have clarity as to what is your invention concept idea and how it is different from implementation. Don't confuse the concept idea itself with how one way of implementing or 10 ways of implementing the concept. Okay, right? So
Hello.
I hope this aspect is clear. Yes, does anybody want to say
Yeah,
anything?
this is Stanley again. Sir,
Yes,
so what you say is like we have to make the claim as wider as possible, right?
yes, exactly.
So it will be covering a major bigger things,
Right.
not very specific to the particular thing.
It's not, I don't call it specific. I call it bringing in implementation detail into the patent concept, which is a mess, which
Better
can be a mess
better to not put the implementation details into the claims.
in the claim. You put it in the description.
Right, right.
Or you can do one more thing. Within the claims also there is a hierarchy. There is a main independent claim and then there are dependent claims
Yes, yes,
which are written below the independent main claim. In the dependent claims, you can put such implementation details or more specifics, right?
right. So
Okay.
one more question, sir.
Yeah.
Sir, you have asked that design and patent. What if I'll go for filing both together at a time?
You can do that, no problem with that. Okay, right? But the
Fine.
patent registration will give you stronger protection.
Yes,
And
yes.
suppose you filed a design application on this plain glass, so when you give the photo, everybody will see it is a glass made of glass material. It has a plain design and it has a steel handle. Okay, and in that scenario, I'm assuming that you got even the industrial design registration certificate. You get it from the design office. Okay, and then 2 months later, you see that some company, some competitor has attached a handle to the glass in the center of the screen, the glass with a curved shape design. Okay, a competitor of yours has attached a handle to the curved shaped glass in the center of your screen and selling in the market. Using your industrial design registration certificate, can you go and stop him from selling that curved shaped glass with a handle in the market? Yes or no? Tell me.
No, that cannot be done. But what I'm telling is both.
But you understood this concept, right?
Yes, yes.
The design registration protection is limited because it will protect that plain glass with a steel handle only because you'll give photos of that. So anybody copying has to copy exactly the same way. But somebody uses the concept of container with a handle and attaches it to a different glass, then they are unprotected. Only the patent that you have applied for and obtained will give you protection in that scenario where again the curved shaped glass with a handle is a container with a handle. Therefore, it is infringing the patent claim. Yes. Sir,
Right.
you have another question, I think, please ask.
So
But I hope this concept is clear for everyone.
yes, yes. In such cases, then what do you think? It's going of filing both the things together is good, design and
Uh,
patent.
it's up to you. Some people, some companies have a lot of money to spare. They are wondering, you have so much money, where should we throw it? So such people can file, right?
Okay.
Okay. And there are certain cases where the physical shape of the product actually gives the functional benefit. Okay. In such a case, and considering the fact that patents are much more costlier in terms of time, effort, and money, right? Some people might, for such kind of products where the functionality or functional benefit comes from the design or shape of the product, they might file only a industrial design application. They may not file a patent. The protection they get on that design will be maybe even less than half the protection that a patent will give. Patent protection is strong as long as you've written the claims well. Okay, but in such a scenario where they file a design and they get probably less than half the protection that a patent gives, but what they'll be looking at is my cost will be less than 1/10, maybe 1/20th of the cost of a design registration. So then they say, as a commercial venture, as a company, we are focused on maximizing our profits at minimum cost. We get the revenues maximized and incur minimum cost, spend minimum time, effort, and money. So in that scenario, such a scenario, somebody for a product where the functionality of the product is dependent on its shape, they might file a industrial design application and they may not file a patent. This will be a conscious decision. They are aware the design application strength will not be very good compared to the patent if we were to file, but they'll see the cost is 1/20th of a patent cost for an industrial design. Therefore, we'll file this. And whatever limited protection we get, it's okay. We are getting less than half protection, but we are getting at less than 1/20th the cost. So that is a trade-off that we do. So business people do these kind of trade-offs all the time. Okay. Now, can you give me one example of a product where the shape of the product is so critical for its functional benefit that it makes at least a little bit of sense to only file an industrial design application and maybe avoid a patent also? Can you give example of anybody give a product example like that? And I can tell you in the room that which you are sitting, I am sitting, there is at least one example of a product like this. Okay, let me give you an example. This thing that you see, the thing on which I'm sitting, this chair, okay? The back of this chair has a particular curved shape design which provides the support to the lower back. It has a kind of a S-shaped design, okay? And my back gets support if I sit on this chair if the back shape is a particular design such that it provides support to my lower back, right? Can you see the shape of this back of this chair provides the functionality of good back support and no back problems, no back pain? Can you see the shape is providing the functional benefit? So imagine maybe 50 years back or 100 years back, somebody first time realized and designed a chair like this. They could very well have filed a design application for the shape. And, to some extent, at least, I'll again repeat, design registration is not as strong. It doesn't protect the concept. It just protects the shape. It's not as strong, but to some extent, it would have provided protection against other people making backs with that same S-shaped shape, because that's a unique shape which supports the lower back, right? Can you see by filing in such a scenario, it would have made some sense to file a design application, avoid a patent, avoid all that time, effort, and huge costs, and get fair amount of protection, not as strong, not even 50% of what a patent will give you the support or the protection, but it would have made sense. Why? Because the functionality of that product is totally dependent on the shape of that product. And you protect the shape through an industrial design registration, even though it's not a mere aesthetic shape, it's actually a functionally useful shape. Get this? Have I answered your question, sir?
Yes, sir.
Yeah. So let's proceed. I hope all this thing, patent, improved technology, design, what to do, how to patent, and what's the mental process that you should go through after you have created that intellectual property. That though you are experts, you will do that all the time. But in terms of IP protection, intellectual property protecting your ideas, your concepts, your innovations, even that requires application of your mind. And sometimes that thought process has to be little different from the normally how a technical person will think. Okay, so you need to understand this if you want to protect it properly. Let's go further in this particular presentation. Now let's quickly go through some important aspects of patents for inventions. Invention is the intellectual property that somebody's created in their head and they've documented, and then they apply for the right called a patent. So patents for inventions. What can be an invention? As we saw, a new or improved product or process can be invention. What criteria does the invention need to satisfy for the patent office examiner or controller to grant you a patent? The three main criteria, and I'm saying three main, there are, apart from this, there are smaller criteria, many criteria also, but the main criteria are these. The invention should be new, it should be inventive or non-obvious, and it should have industrial application or usefulness, utility, right? It has to meet these criteria for the invention to be patentable. If something is old, you've created some technology, you didn't know, there was 5 years back somebody already created this product, this new technology, and then 5 years later you created, reinvented the same thing, then the patent office will not grant you a patent.
Hello,
Okay,
sir.
right?
Hello.
Yes.
Yeah, this theoretical part everybody is known. So slightly go quickly the
Yes,
theoretical.
yes, I'll go through this quite quickly. And one thing I would like to caution everybody is new and inventive is absolute requirement across the world. You can't say, oh, this technology is not known in India, so can I get a patent? You can't. Registration required when before you disclose or use in public. Patent term is maximum of 20 years. It can't be 20 years because when you apply for a patent, it takes time, 1, 2, 3, 4 years to get a patent. So effective term will be 20 years minus how long it took to get the patent granted. What are the requirements to apply for a patent? You need a detailed technical description of the invention along with the drawings explaining the invention. Based on that, a patent application can be drafted and filed with the patent office. What's the procedure? There are separate procedures. You file the application, draft and file. It gets published after 8 months. I'll not go too much into this since you might already be knowing these things. There's an optional procedure, important thing to note, called a patentability search that you can do before or after filing to check whether what you think is a new and inventive invention really across the world is it new. There are something called a patentability or prior art search that you or we can do, which will search worldwide databases to check whether this technology is new. And there are separate costs for searching, filing, reply to examination report, renewals, etc. Timelines: 18 months after filing it gets published, then eventually if you requested examination it will be examined and the final decision will come. Now, important thing to note, a Indian patent application will not protect your invention outside of India in a foreign country. To protect in foreign countries, you have to go and, based on the priority of your Indian application, you have to go and file in foreign countries within certain time limits, 1 year. Okay, Paris Convention, PCT, these are international treaties which can be used to facilitate foreign filings. We don't have time to go into details of this in today, but you should be aware. Indian patent valid in India, then there are international agreements which will help you file in foreign country. And obviously, foreign filing costs are different in each country for each stage of the whole process. Okay. Now, looking at your area of interest in the agricultural domain, what possible types of inventions could be there for which you can file patents. And we'll also a little later look at things which are excluded from being patentable, which might be relevant to your domain of work. Okay. So possible types of inventions in agricultural domain, it could be, for example, composition, insecticides, pesticides, fertilizers, manufacturing processes for manufacturing maybe insecticide or fertilizer or some other type of composition used in testing, or manufacturing certain agricultural machines or devices, right? Then the new or improved design or functionally better agricultural machines also could be patented when it comes to and it is not just a tractor, it could be an improved plow also, an improved way of releasing water, irrigation system, or this blah blah, testing devices to test chemicals, to test insecticides, to test whether some plant is diseased or not. You can have machines, you'll have chemicals used in these kind of things. These are the various things that you might have, types of inventions that you might have in agricultural domain. Now here you would have noted that under the category of invention for patenting, I have not mentioned plant variety because there's a separate law which covers that. We'll come to that. Okay. Now, in patent applications, trial or test data, conducting tests and providing data in the application is especially important if you want to get patent registered, especially for compositions, medical or pharmaceutical or, chemical compositions. It is very important to provide test data which proves the efficacy of those compositions. Very important to keep this in mind when you're filing that. Another very important thing, if in your invention, the invention uses biological material or resources from India, sourced from India. Okay. then you would, for obtaining the patent protection or other IPR protection, you would have to get approval. You would have to apply to and get approval from the National Biodiversity Authority, Chennai, under the Biological Diversity Act 2002. This is very important. If you don't get this approval and you don't sign an agreement with the NBA, then you can't get a patent. The patent examiner, even if they can allow it, they'll put the certificate issue on hold till the time you get this approval. Very important to understand this. Now, when we say okay, using biological material or resources, that doesn't mean physically you have to use. In a patent, you're not doing anything physically, you're just giving the idea. After that, 5 years later, a company will actually buy that biological material and use it to make your invention, right? Right? Nonetheless, now just because you're mentioning in your patent that your invention uses a biological material, you'll still be required to get this permission. Get this? It's not that 5 years later, when the company goes and it's making that product and then they buy the biological material or source it from India, then they have to apply for NBA permit. No. Even to get an IP right on something which mentions or uses biological material sourced from India, you need to get this permission. Very important to understand this. The patent office doesn't allow patents otherwise. Okay. Oh, it's also important for you to understand what are the things which are excluded from being patentable invention. What are not invention? And when I say invent or not invention, mean not patentable inventions. What I mean, because we are talking about patents, we are not doing a general discussion on general news, etc. We are talking about patentability of invention. So under Section 3 of the Patents Act 1970, certain things are excluded from being patentable, even if there is some sort of IP or some innovativeness or newness in that. Okay. For example, mere discoveries are not patentable. Okay. For example, mere discovery of a new form of a known substance, which does not result in enhancement of the known efficacy of that substance. Right. Some examples of this are salts, esters, ethers, polymers, metabolites, etc. Various things, Basic, the thing which is providing with the functionality remains the same. A little the form of that you're changing and efficacy remains the same. Then it's considered merely as a discovery. It is not considered as a patentable new creation or a invention. Okay. Mere admixture of known substances or things or aggregation of the properties or components thereof. Okay, where if you are adding 1 2 3 4, okay, and the or I'll just give an example. They say if you are adding 1 and 1 and the outcome is 2, then there's nothing. It's a mere admixture, aggregation of the known property of these two things. Okay. However, if there is a scenario where you are making a mixture or adding things together, you are taking 1 and 1 and the result is not 2, it is actually 11. Means there is something different, some magic happening, some synergistic result is coming. Such things will be patentable. 1 and 1 give you 11. That's unusual, unexpected, synergistic. That will be patentable. But if you are adding 1 and 1 and the result you get is 2, mere aggregation of even the material and the results are also a mere aggregation, then that is not patentable. Okay. Now, arrangement or rearrangement, okay, of known devices or items, etc. Wherein each of the components can work independently of each other. Such things are not patentable. Method of agriculture or horticulture is not patentable. Very important for you people to note this. Method of agriculture or horticulture, even if it is innovative, is not patentable. Very important one. Process for treatment of human beings or animals, not patentable. It could be a medical, surgical, diagnostic, therapeutic, any for human beings or animals, not patentable. Okay. And for these things, there are not even other laws which will provide protection. Okay. Right. Traditional knowledge. Okay. Traditional knowledge which has been known a long time in India may not be very well documented, but if it can be proved it was in existence, such things, traditional knowledge cannot be patented. Okay. Plants and animals cannot be patented. Important for you again. Plants and animals cannot be patented in whole or any part thereof. Okay. Other than microorganisms. For microorganisms, there are other laws, right? But generally plants and animals can't, but plants can be under the Plant Varieties Act. That is what we'll come to. So under patent law, you can't protect, because when India was required to comply with the TRIPS requirements and provide protection to plant varieties, They didn't put it in the patent law. Patent law says plants and animals can't be patented, but the other law separately, which they made specifically for plant varieties in India, under that you can protect certain types of plant varieties, which we'll be looking at very soon. Okay, I hope you understand the meaning and implication of these things are not allowed to be patentable inventions in India, and you can say most of these things are not allowed in most countries. I'm not saying all countries, but in most countries, these will not be allowed for very obvious reasons. Like you don't want plants and animals, very freely be patentable, or methods of treating human beings or animals, because for government that will be very sensitive issue. People are suffering and you don't allow them to be treated, and there's a patent causing problem. No government will allow that. Okay, so these are the some of the reasons why it's not allowed. Okay. Now, having gone through this, before we come to the plant varieties, I just want to speak about this whole thing called protecting technologies through patents, means patenting an invention or patenting technologies. Let's quickly look at this thing. Okay. Now, Stanley sir, it's 11:23 approximately now. So we started at around 10:15. So I would request your permission say about 1.5 hours, that's about 11:45 tak, I can continue with this with your permission, and a little over that if required. Okay.
Quickly.
Sorry.
You can squeeze slightly quickly. Yeah?
Yes, I'll do that, sir. I'll do that. Okay. So when we talk about patenting an invention, first let's look at what is an invention and the process of inventing and what is the meaning of invent. Invent is an action. Okay. In this case, note it's an invent is a word is an action word, but it's not a physical action. You're doing running around, doing something, writing something. No, it is an action in the nature of creating by thought. Intellectual property. Intellect means mind. In the mind, you're creating a new invention, concept, idea by thinking, by thought. And important thing to notice, invention is originating something, some idea for a product or a process or some technology which does not exist in the world. It's not publicly documented or used anywhere in the world. That is invention. So first you must have an invention. Invention is very different from merely discovering things which are already in existence. Okay. For example, if a team of scientists, imagine maybe 100, 200, 300 years back, they studied solar radiation. Solar radiation means nothing but sunlight. Okay. And after 1 year studying solar radiation using some telescope or maybe some reflectors, lens detectors, etc., they studied. And at the end of 1 year, that team of scientists, PhDs, researchers, they published a research paper where they documented the properties of solar radiation. Okay. And a lot of useful information human beings came to know about through that research paper and through their work. It was very valuable and useful, informative work, right? But was it possible to patent that research paper? Was there an invention in that research paper? The answer to that is no, because solar radiation, sunlight has existed for billions of years. Sun has existed billions of years. Human beings have existed less than a million. So those team of scientists cannot claim they invented solar radiation, they created solar radiation. No, it was already there. They just found out about it. They discovered the properties of something which was already in existence. They didn't create it. Therefore, that research paper and the contents not patentable. Okay. But imagine that is such a valuable, useful, informative document, and lot of aspects on properties of that sunlight are documented there. And imagine there is another team of engineers and technologists, the applications people in a different country. They get to read this research paper, which was published by this team of scientists and researchers. Okay. And then they come to know that this solar radiation is not made up of one thing. Okay. There are different aspects to it, different things within solar radiation. For example, one aspect of solar radiation, one aspect of sunlight is electromagnetic waves. Solar radiation is made up of electromagnetic waves, right? Second thing that they learned by reading that research paper was solar radiation is also made up of energy particles called photons. Okay. So it is made up of electromagnetic waves and energy particles called photons. And the researchers also documented the properties of the waves and the photons, at what speed does the wave travel, at what speed does the photon travel, what is the wavelength, what is the frequency of the wave. Okay, if it hits some medium, what will happen? Will it get deflected? How much energy does each photon have? In what energy states can it move between? Okay, at what rate does the energy particle photon oscillate? All these details are there. Okay, and since these people are technologists and engineers, they want to use technology, they want to apply it somewhere, know-how somewhere. Okay, so then they think of, okay, everybody is looking for more and more energy, and there this solar radiation has these energy particles called photons. Why don't we use it to be able to harness that energy? And then they think of, let's make a solar heater, either to heat water or food or something, or capture the solar heat and store it and use it. So then they physically design and devise on paper a solar heater. How will it be constructed? What parts will it have? Will there be some lens concentrating the solar radiation, the sunlight? Will there be a detector? Is there a reflector? All these things they define. And by the way, as you know, the sun will rise in the east in the morning, travel across the sky, and set in the night in the west, right? So the sun itself is not steady in the sky, no? So then the mechanism, the solar heater that they are devising, understand that should have the ability to move along with the sun. All these physical design of the solar heater, they described in words, made a document, and they made drawing such that anybody can make that solar heater. So is this an invention? Is this something new and inventive? Did a solar heater exist before this? Or the idea for that is a creation of these people? Yes, it is a creation. And this kind of thing didn't exist. And is it useful? Yes. When you implement this idea, this concept of solar, somebody can, using their description, they can implement it, they can make the solar heater, and then you'll get that energy which you can use for heating or cooking or whatever, right? So can you see here, when you apply this knowledge and make a physical device which didn't exist before, you have an invention, you have a technology for patenting. Get this? Okay. Now, physical construction is not necessary for patenting, right? You have to get the idea, document the idea. Maybe to actually make a prototype, implement the idea, you will need an investment of 50 crores, and you'll need 6 months to make it. So you'll need a big company or a big businessman to invest that. You can't do that. You're a technically qualified, capable people who can come up with the ideas, but you don't have the resource to actually make it or make the prototype or test it, right? So what is patented is not the prototype or the implementation or one or two implemented. What you patent is the concept. You give the concept in terms of a detailed technical description and drawings, and based on that, you can apply for and get a patent. Physical construction not required. And as you would have noted, patents are granted for technological arts, maybe agricultural engineering or related items, electrical, mechanical, IT, software, hardware, aeronautics, the telecommunications, chemical engineering, pharmaceuticals, biotechnology. Can you see technologies are patented, not other business, social, spiritual, or cultural innovations can't be patented. The patent law does not cover them. Nobody is saying that those are not innovative. They will be innovative, business methods, innovative, spiritual innovations, innovative, cultural innovation, innovative, but they are not technological. Therefore, patent law doesn't cover that. Okay. Another very important thing to understand is most inventions are improvements or additions to existing technology. There is an existing product which is doing fairly well, but it has one or two problems. Now, suppose you make an improvement in that existing product or add a new product, a part to it, make an addition to it, and that problem with that thing is solved, then that itself is an invention. Most of the inventions which are created, patent filed for, and valuable patents granted are improvement or addition inventions. There is some existing thing, somebody improves it, gets a patent, and they can. What you have to look at is, when you're looking to file a patent and get a patent on a technology, don't look at merely how high tech that technology is, how complicated that technology is, how big that technology is. If it has all these qualities, it's fine, no problem with that. But what you really need to look at is, how useful can this technology be in the market out there? Maybe the technology, the innovation, the idea itself is small, but if you see that this idea is going to be used by thousands or even lakhs of people, right? Then it makes sense to file a patent for such technologies. Technology is small, simple, easy to implement, but it lakhs of people will use it and lakhs of people will pay you money. Then you should file a patent. Get this? On the other hand, if you have a very high-tech technology you've created, very complicated, And to make one such piece, one prototype, it will cost you, $1 million, right? Okay. Now it's a great technology, greatly advances our knowledge about science and technology and those products. Great technology, very complicated, but you have to spend 1 million to make it. And then you also realize that there are hardly 4 companies in the world who might buy this technology and use it. Really. Okay. They might, but out of that 4, only one company shows some interest and nobody buys that technology. So such a technology, even though it's very high tech, very complicated, great invention, it doesn't make sense to file a patent on that. Because what will you do with the patent? Because patent is a right to stop others from using your technology. Anyway, nobody is using your technology, then who will go and stop with your patent certificate? However, that simple technology, which is very useful for lakhs of people will be using it. Now, you want to make sure when they use it, they don't do it without your permission. You want to stop them if they have not taken your permission. In that case, it makes sense to file a patent. Do you get this? Many technical people, many researchers, scientists, innovators, they undervalue their work, saying what? It is a small improvement. Existing technology, process, product was, I have just improved it a little bit. I've just made a small addition or a slight modification in the design. What is there to patent? This kind of work we do every day. Why should we even take it to the department head to get an evaluation done? Should we file a patent? Don't undervalue your work. Don't make this mistake. If you see, even if it's a small, simple invention, if you see it has some practical utility, it's solving a technical problem, there is even a small technical advancement, and you see there can be a large market for it. Okay, then definitely get it evaluated, bring it to the notice of the concerned team, people, the heads, and get an evaluation done to decide whether we should pursue a patent or not. I'm not saying rush to file a patent. Get at least an evaluation done, and properly based on the evaluation, you decide whether you want to go ahead with that or not. And the evaluation should be based on multiple factors. One will be the technically how strong it is. Second, legally, can we get a strong patent or IP right on this? Thirdly, is there a good big market that we estimate? Nobody has a guarantee whether it will succeed or fail in the market, but you must have a sense that there can be a good strong market and demand and usability in the world out there. These are the 3 main criteria based on which you will do an evaluation and decide, should we protect the patent or IPR or no, should we let it go? Okay, very important to understand. Okay, now let's come to protection of plant varieties. In India, there is a law for this. Okay, around 2003 it came into force. Okay, the Protection of Plant Varieties and Farmers' Rights Acts 2001. Okay, this is the law that applies. Now, it was possible technically speaking, it was possible that the Indian government could have said, okay, plant varieties can be patented, but they didn't put plant varieties in the patent law. Patent law says no, you can't patent plants and animals, even if it's new variety. Okay, so what they have done is they have made a separate law for this. That law in India, that act is called the Protection of Plant Varieties and Farmers' Rights Act 2001. And what can be registered under this? New or extant plant variety if it conforms to the criteria of novelty, distinctiveness, uniformity, and stability. Such things, such plant varieties are registrable. Okay. And how will this, so plant variety, what will you hold in your hand or have in your possession which will actually be patented? What's the meaning of plant variety? There will be some seeds that you might protect, a new variety of seeds, or it could be some material which is capable of being reproduced or propagated. Some maybe stem of, sometimes people cut stem of some plant and use that to grow more plants, something. So it's a seed or a propagatable material or a reproducible material based on which that organism will grow or that plant will grow. Okay, such are the physical things that you would be registering if it's a new or some extent thing with some new characteristics which you have created. Now, who can be an applicant for registration of a plant variety? Any person claiming to be the breeder of that new variety, or any farmer or group of farmers or community of farmers. It's not just individual, it could be a group or a community of farmers claiming to be the breeders, or it could also be a university or agricultural or research institute which is actually working on creating these new plant varieties. In other words, being a breeder of the variety. Okay. These are the categories of applicants who can apply for registration of a plant variety. What are the rights that the owner of that registration gets on that seed or on that propagatable material or that reproducible material? What are the rights? The owner of the protected variety, okay, or that breeder's right, the owner of that right has the right to produce, sell, market, distribute, import, and to export the variety. Now, is this right permanent for 50, 100, 200 indefinite period or for limited? Okay, it is, these rights are for a limited period. The duration of protection for registered plant varieties in case of trees and vines will be 18 years. Other crops will be 15 years. Okay, the following plant species can be registered. Okay, as of now, not that any and every plants can be registered. Now this is just a sample list I'm giving you. If you want the exact list of the exact plant species which can be registered as of today, okay, you should go to the website which is mentioned at the bottom of the screen and check over there, or some relevant government source. You can check what are the exact species which can be registered as of today, because this information may not be complete or maybe a little out of date actually here. So you can protect cereals like rice, wheat, maize, sorghum, millet, etc. Legumes like chickpeas, mung bean, lentil, blah blah blah. And in the fiber crops, there are four particular species of cotton which you can protect, and two species of jute that you can protect. Apart from this, there are proposals for including more and more species and items in this list. Okay, so this is not a static list. If you want to check, you have to go and check currently before you go and file an application, or before you take a decision regarding what to protect, etc. Okay, always check the latest information. It is widely available on the relevant websites, and on the website you'll get the updated information. And what do you, are you required to submit samples of the seeds or of the propagating material? Yes, you have to deposit this before you can get a registration. You have to deposit this with the concerned authority so that they can conduct a test on that before they decide to give you a registration. For more information about plant varieties, how to go about, what are the fees, what are the costs, how to do it, which is the address of the relevant office, etc., you can go to this website mentioned on the screen over here. Okay, right? So with this, we come to how much time do we have? We are, I think, about 5 minutes. So let me complete with this slide. I had another example to illustrate the process, but it's okay. We need not go over that as we don't have the time. So an overall IPR protection strategy and certain aspects, that's what I want to talk about. This is very important for research organizations or research institutes or educational institutes which do research work, to look at these aspects. One is protection of your intellectual property is not automatic. If you create the intellectual property and don't take action to protect it through the corresponding intellectual property right, you can take it pretty much that your intellectual property is unprotected. It is liable to be used, misused, and taken advantage of by other people. Okay, and you don't have any protection or right on that unless you take action. So what is the action that you need to take to protect? You have to firstly create the intellectual property. Okay, create or invent it. Then somebody has to recognize, oh, you know what, we were working on this thing and this is what we have done. We have got this nice innovative idea or this new design or this new intellectual property. Somebody has to recognize that firstly. Okay, very often it will be the people, the team of people who actually worked on it. They should recognize what we are doing is not the same old daily regular routine work, but here some new results are there, new things have been created, there is something unexpected or innovative happening over here. You have to recognize. Then you should decide and take it to the concerned person, get it evaluated. Does it make sense to file an IP application? If so, what kind of a thing? Should we do it? Should we not do it? What to do? All this you do an evaluation. And then once you decide, you will prepare and file and process the IPR application with the concerned intellectual property office. Okay? The institute organization, very important, you need to have an IP policy covering various aspects. This could be, do you encourage or do you discourage, creation and registration of intellectual property rights? Okay, who will work on it? Who will have the ownership rights on it? who will have responsibility related to, incurring the cost, following up, doing the work for IP registration. Okay, who will decide to whom to license this, who will use this technology, who will use the IPs. All these things have to be how will the people who work on it be compensated, who will have rights on all these things have to be decided. Ownership and roles and responsibilities, these have to be clarified. You should have clarity on this, because understand this, there is a certain institute or organization which does the educational or research work. Then there are human beings, there are actual work people who use their brains to create this. They could be students, they could be faculty, there could be staff, there could be people, who are being incubated or working in the incubator. There will be affiliates with whom you would be working. You have to have clarity on all these ownership, roles and responsibilities, and document that through non-disclosure agreements and other kinds of, how to work on it kind of agreement. How do we take this forward, those kind of agreements. So confidentiality and non-disclosure is one type of agreement. Other thing is, what do we do with this? How do we bring it to the market? How do we make the prototype? Who will have the right to decide? All these things have to be documented and very important. Now, when you are coming up with IP and you're protecting even that IP through an IP right, it's important. Finally, the target, the purpose, the objective has to be that this is commercialized. The invention or the technology is commercialized, means it is used by people out there in the world. That is very important. You are not doing this, as a time pass activity, right? You're working on these things so that finally they are used in the world out there, and there are people, organizations, companies, institutes which benefit from this. So you use it in-house, or you license the technology, or you can outright sell or assign the technology, or you can collaborate with partners or affiliates to jointly develop and distribute the thing. So something or the other, your objective has to be there in terms of what you do with this technology or the IP rights that you applied for and obtained. Okay, so with this we complete today's session. If anybody has any questions, you can ask. It's 11:45 right now. Okay, and you can ask any questions, unmute yourself and ask the questions right now if you want.
Dear sirs and madam who are there and online, it's time for you to unmute and ask if you have any questions. Later we will ask.
Okay, or if you want, you can ask questions later on also. You can send me an email or give me a call. My contact information is on the screen. Or you can direct your questions to Stanley sir also. He will forward those to me. Okay. Anybody has any questions, any doubts, any queries, you can always ask that.
Who are online in Zoom, could you able to hear us?
Yes. You're asking me, sir?
Yeah, not you. Any other than you.
Mm-hmm.
Somebody was telling it is not audible, or they could not be able to answer. Hello? Anybody from different institutes? Wants to ask very specific questions, you can ask now. So just to start with, I have one thing, sir, that
Yes, sir.
told that trademark, if it has been used long before, that
Mm-hmm.
is better chance for getting the trademark, right?
Mm-hmm. Yes.
So our
Better chance for the person who's been using for a long time. Okay. Another company, it will become hard, actually.
exactly, that's what I mean to.
Yeah.
Our institute is it's Bharatiya Kadan Anushandan Sansthan long before. Okay.
Mm-hmm. Mm-hmm.
From March onwards, it has been changed to Sri Anna Anushandan Sansthan.
Mm-hmm.
So we filed a trademark immediately. It is
Mm-hmm.
yet to receive registrations.
Mm-hmm.
The thing, but a better chance we will get that. That's not an issue. My point is, but the time of when we are starting that one, I have given only after March. Means from
Mm-hmm.
April 2023 onwards, we have started using that.
Mm-hmm.
But is there any chance of giving that prior one, that Kadan Anshandan Sansthan? Everything is that logo, everything is same. When down, will very small letters it is there. ICAR, that Kadan Anushandan Sansthan, Kadan ka jagah, now it has become Shri Anushandan Sansthan. Hello?
Okay. I can't really comment on this because I can't see what was the mark that you had registered.
Okay.
Firstly, my question will be is very often people mix up the intellectual property right types. Okay, they might have done some filing. They think they have done a trademark filing, and whether it was registered with the government is a separate question. Secondly, in what form had you registered the earlier mark? Was it a combination mark? You had registered a combination name, some tagline, some logo, or you had separately registered the name, the logo, and the tagline. So the answer can be provided only if you provide the details of what has actually happened earlier and what is the new thing that you're doing now. We'll have to talk very specific. Theoretically, I can't say anything. Right? Did I address your question, sir?
Can you see the screen which is shared now?
Yes, I can see it, sir.
So you see in the right hand side, last logo, that is IMR, it is there, no?
Mm-hmm.
The same logo, same thing, everything is same.
Mm-hmm.
Down there is Shri Anushandan Sansthan. Instead of
Mm-hmm.
Shri earlier it was Kadan.
Mm-hmm.
So earlier it was not registered.
Mm-hmm.
One part.
Mm-hmm.
The second part, what my question is, I have registered, I have put for registration this logo.
Mm-hmm.
And I have given that it has been used from April 2023.
Okay.
I personally believe that it will be registered. That's not a big issue. My question is
Okay.
whether I can show that it has been used long before
You
2004.
can, while filing the application, I don't see any harm in showing and saying this is a minor change in that.
Okay, right.
Yeah, there is no harm in that. They may consider it or they may not consider it, but definitely there won't be any harm in it.
Right.
Right?
Okay, sir. Thank you.
Thank you.
Anyone else? Madam?
It is very interesting. Thank you very much for enlightening us. Are you able to
Thank
hear?
you, ma'am. Yes, ma'am, I can hear you.
Yeah, then I just wanted to have, can you post to share with Dr. Stanley also the latest free patent search engines?
Sorry, share the what patent?
Free patent search engines.
Okay. Right. I can send you a list. There are many. In fact, I can tell you right now, the various patent offices have their own free patent databases. All the government offices across the countries, they have their own free. Like the US Patent Office database is an excellent source of information, wonderful source. Okay, European Patent Office has its own database. World Intellectual Property Organization, WIPO, has its own database, eSpaceNet and all these things. Then the Indian Patent Office has its own database. Then there are so many other countries' patent offices, they have these databases. So remember, US Patent Office, European Patent Office, WIPO, these databases, Indian Patent Office databases. Then there are a non-patent office scientific and technical literature you can search. It doesn't have to be patent literature. It can be any scientific and technical literature. Google Patents is a good source. Google itself is a good source. Google. Apart from that, there is another website which is a non-governmental free website, which is Free Patents Online. Okay, that's an excellent resource, right? Free Patents Online. This is maintained by some other, separate organization, not a patent office. Okay, these IP.com. These are the websites which are excellent sources of information.
Oh, yeah. Then one thing, like just want your advice. We obtained a patent for some technical on genetic transformation. We
Mhm,
filed in 2009 and we got the patent a year ago. It took pretty long time.
mhm,
It was a very bad. Then it is only a process patent in the sense that time transformation was used widely. Then
mhm,
GM crops were used widely. So we thought that developed a method that is very easy. But
mhm,
then after then 2011 onwards, there is a ban on GM crops and the technology was no use. So
mhm,
now when we got the patent, now again the genome editing technologies are revived. So
mhm,
in fact, the idea was that not to, so that nobody could patent this technology. This is a very easy technology what we have, so
Hmm.
that nobody else, no other company should patent this technology,
Hmm.
such that no public in organization can use it.
Hmm.
I
Hmm.
hope I'm clear. In the sense, earlier people
Hmm.
used to ask for genetic. You pay and give them the seeds. They used to give transgenic plants.
Hmm.
Then we developed a small technology for that, and we patented it.
Hmm. Hmm.
Now, should we continue with the patent or not is the issue. So, can
Why
you?
will you not continue with the patent? Why? What's the reason why you're thinking whether we should continue or
No, no.
not?
Yeah, that maybe it is, since it is not giving any remunerative benefits. It is not a like a commercial patent or something like that, but it is on
Hmm.
a technology
Hmm.
where you just stop people from using such a common thing.
Okay. Right. So let me clarify 2, 3 points. Firstly, patents are not filed by people or organizations or companies so that nobody else can file a patent. That's not the reason. If you want somebody not to file a patent on some technology that you have created, okay, you don't need to file a patent. Just make a disclosure of that technology and put it out there in public. Once that technology becomes public information, nobody can file anywhere in the world a patent and hope to get a patent. They can file, but their application will be rejected because you have put that know-how, that technology in public domain somewhere in the world. It's visible. So then nobody, because it will not meet the criteria of being new and inventive. Okay. Why do people file patents? Because they want to get an exclusive right on that invention or technology. Means people file patents because they want to stop others from copying and using or misusing that technology without their permission. So
Yes.
you should file a patent only if you want to do that. Otherwise, if you want to stop others getting a patent, just publish that know-how in a public domain somewhere, and then nobody will get a patent. Right? Now you're saying the patent you have got, but it's of no commercial significance. I don't know the reason why you're saying it's not of commercial significance. Maybe because nobody is using it, or maybe you were not able to give a license, or maybe you can't use it. Now, if you feel strongly that it has no commercial significance, nobody is using it, then you may not maintain the patent anymore. You may not pay the renewal fees anymore. It's up to you. I can't really comment or give you a decision, do this or that, because I don't have the details of that.
Yeah. Oh, okay. And then there are some millets specifically to India, like Kodo millet and all. Do you
Mhm.
think that as a nation we should patent or do something at the international level?
It's up to you. As a nation, will want to do certain things. For example, if there are these local millets specific to India, and if they are already in public domain, right? Nobody has a IP right. When they were firstly created, then nobody got a IP right on that or any aspect of it. Then now it's in public domain. So you can't get a registration, any IP registration on that because it's already in public domain. Okay, it's common public property for a long time in India, right? So nobody can get a protection. But what you can do is sometimes in India or in foreign countries, people try to get some patent or other IP protection on that variety which is known in India, which is there existing and specific to India. So to prevent such misuse and other people or foreigners getting any IP rights on that, what you should do is document those millets and those things specific to India and put that information in a clearly visible public space online somewhere, preferably. Okay. So that then nobody can apply for and get any IP right on that because it's already in public domain, right? That's the action that you need to do, right? So, for example, just to give you an example regarding this, earlier we used to hear many cases of companies in foreign countries filing patents on things which in India have been known for thousands of years, traditional knowledge. Okay. And the reason why sometimes those people or companies in foreign countries could get a patent granted in the foreign country was because this traditional knowledge was not properly documented, okay, in proper detail. And this traditional, whatever documentation existed, was available maybe locally in some district or some city somewhere on one state somewhere, which was not well known anywhere. Okay. Now, this problem, when the people became aware, the government became aware of this probably 1 or 2 decades back. What they did is they set up this organization and they gave responsibility to some team or some department or organization for creating an online database of traditional knowledge across India, right? And they started collecting all this information which is already known in India thousands of years, but somehow people, because they are not published properly, they are not like highlighted and properly documented on a widely available online database, people were misusing in foreign countries. So they did this, and by now, to a substantial extent, all this kind of traditional knowledge is on record and documented. So people will not find it so easy to get a patent on these kind of things, because now it's publicly available online. Maybe sometimes you have limited access or you might need to pay money for it, but it's there online on the databases to a large extent. I don't know whether 100% of that work is done. Nothing gets done 100%, but to a large extent it has been done.
And then one more, for the benefit of students, can you advise some free online courses that are available? Earlier, some courses were there. So these give an additional enrichment to their CV. So
Okay.
some students, many are there online here in the, so maybe you can suggest some. Netherlands used to have some course like that.
Online courses on what?
IPRs.
Intellectual property rights. Okay.
Yes.
Now, in terms of intellectual property rights, what I can suggest is go online and search. You'll find, many dozens of it. I'm not really aware which one is right, which one is good quality, which one is recognized where. I'm not really, and I wouldn't want to comment because there are so many of these things. It would not be fair for me or Khurana and Khurana to comment. This one we are sort of, almost like certifying, we really don't want to do that. It would not be appropriate for us to do that. But online, if you go and search, you'll find literally dozens of these things. Very often people do courses by WIPO, on intellectual property related matters.
Yeah.
That's all I can mention. Because WIPO programs have some value as certifications.
Yeah, sir. That is true. I did my one online thing in Viper, so that was really useful. And I did a couple of things in India also. It was quite useful. But apart from that, as I told, I have done my PG diploma in IGNU, so it was useful for that IPR and other things.
Right.
That's
Right.
good. That so I can advise them about that. And just can I ask who are there in online to switch on your videos for a minute, so that we'll have a photos for documentation.
And sir, I would request you to send me the photos also, sir.
Yeah, sure. We'll do that. I request the people who are there in online to kindly switch on your videos so we can see you and take a documentation too. Please switch on as early as possible so that we'll have a group photo together. As our director told, this is one of first of its kind that we are doing this awareness program. Apart from that, we will do very specific programs on patents, copyrights, and other things very specifically, so that it will be all those doubts will be cleared. I am very thankful to Parvez, Mr. Parvez, who are giving this wonderful lecture, because it cleared many of our doubts. But still, as because of time constraint, we could not able to do so much, as he was also telling. And again, because this is day after many holidays, so everybody was busy here and there. That's why we had to squeeze it. Otherwise, we were really loved to listen to you for more time. Sorry for that inconvenience. And
No
we'll,
problem, sir.
yeah, we hope,
Time is a factor we always have to keep in mind.
yeah, we hope we'll have further programs like this. Uh,
Surely, sir.
Further, somebody can, if you can switch on, it would be very good to take a photo. And if anybody who are there in online have any questions or suggestions, that also you can unmute and talk. Particular to this ZTMC, I want to tell 2-3 things. That we do have a review on 8th January, and Honorable ADG Madam has given so much of targets and very specific targets this time. Unlike earlier time, whatever we have done, we used to report, but this time it is very specific. This many copyrights, this many patents, like that. I know it is very difficult to cope up with those expectations. I told Madam ADG also, Madam, it is very, very, very tough for us to go to that level of expectation, but we'll try our level best. So 8th, there will be a review meeting. And this program, particular program, we thought of keeping is as exactly as our director told. It's an awareness program just to make you understand this, what are the implications of this patenting or copyright and other things, just to attract you people to file more and more IPs. That as Honorable DG sir is also telling again, time and again, that we do have one scientist, one IP, one project, one IP. That budget based on projects and many other things are coming. New policies are coming. So once we have to stand for those expectations of ICR, we ask our institute wise or individual wise also, we have to do identify the technologies first, then go for exactly which kind of IP is good, protection is good for that. That we have to see and we have to protect it properly so that we can do commercialization also perfectly. That increases the whole things like that is the most crux of the thing, no? We do have this, these are intangible assets, but it is very, very costly and very important assets for as an institute as a whole, or also particular to an scientist. So we expect from ZTMC, we expect all the institutes which is under this ZTMC to file more IPs in the coming time. And if you have any queries or anything related to that, or any kind of thing, anywhere you are stuck up, you are free to give us a message or call me. We have a WhatsApp group, no? So we can put in there, or you can tag us, so that if we will be of any help, we will be very, very happy to do that. Thank you. And if again last, if anybody have any questions, you can ask now, or we can close it. Anybody?
Any,
yeah. Yeah, please.
Sir, any format, sir, for presentation on 8th? That's review meeting.
It is not like a format will be shared shortly like that they told, but still not given. The same thing what we had done earlier, no? Like IP, what are the IP portfolio? It is there. That must be first one. Means of patents, copyrights, what are those things? It is there only from this January to December, or April to December. This is
April to December.
Yeah, April to December. What we have done, those things we have to give. What is the commercialization? What is the budget utilization? And other things will be there. That is a common thing. Like every time we do, no, the same thing only. But
Okay.
we don't have a target. What I mean to say is, earlier, whoever is done, yes, I have one patent, I have 2 commercializations, like that we used to usually tell. But here, this time, they have given a target for each and every portfolio. That's what is the importance. And many a times ADG Madam used to tell that based on our performance only, our budget will be given. Already our budget is very less, so we have to strive hard to get that budget also. That's what is the crux. Anything related to today's one? Today's program? If nothing is there, I, on behalf of Director ICR-IAMR and the Chairman of this Zonal Technology Management Unit at ICR-IAMR, which comprises of 10 research institutes, crop science research institutes of ICR South Zone, we thankfully acknowledge Mr. Parvez Kudroli, who has given a wonderful lecture on overall awareness on this IP, intellectual property rights, especially on patents, trademarks, PPBFR, as I requested him to put on PPVFR. He could able to thanks to you especially for that. PPVFR also he has touched, and many other things, many questions. It was a wonderful thing that he has given some examples like the glass and other things. It was good to listen. I know that the time constraint was there, but still you could able to do that, sir, wonderfully. Thank you very much on behalf of all of us. Thank you very much, sir, for this wonderful program.
Yeah, can I say something?
Yes, please.
Yeah, so I would like to thank everybody. Thanks to Dr. Tara Satyavati ma'am, Stanley sir, the entire team management, everybody, all the participants at the Millets Research Institute as well as in other locations who joined online. Thank you very much for giving this opportunity, all your help and support, and for your participation. If you have any questions, you can always, ask me about it or direct it to Stanley sir, and we will get that addressed. Okay. And any other information, any program or any support with any aspect of IPR or how to make the IP policy, etc. How do we safeguard in the institute? These are very important questions, and based on your interactions with actual farmers and agriculturalists, if there are any issues, etc., you need to work out some agreements, contracts, etc. We can help you with all these aspects at Kurana and IIPRD. So please let us know about that. Thank you so much for all your help and support.
Thank you, sir. Thank you, one and all. I thank all the respective directors to spared people to join in this program. Thank you. Special thanks to all those people who have joined from different institutes too. And from us also, people have joined from IIMR. Thank you, one and all. Thank you very much. We may leave now.